move we accept the minutes.
Second.
Any discussion, any recommendations or questions about the changes?
I do have one question.
Appellate section.
It is under appellate section. Under transfer of license, I wasn't clear that we were going to allow, like, if you gave up your license, gave it up in the board, the commission, someone have to reapply, they can't just, can they just transfer, like if I own a cultivation facility, can I just transfer it to Travis if the board approved it, or do they have to just relinquish the license and go through the whole application process? Will we allow transfer? I saw that turn out.
So it talks about transfer of license under 18.
Yeah, page 10, it says transfer, I was just curious.
That's
if
under
that was-
appellate procedure.
That's the appellate proceedings.
But it doesn't,
16
16 is transfer of license. Under section E, in order to obtain approval to transfer ownership of a license or an entity that holds a license by its individual agent, principals in ownership, board members or officers, the licensee shall submit to the commission an application for license transfer on a form and in a manner prescribed by the commission.
Okay, so then we will, okay, just making.
So we would
We have
allow
to
transfer,
transfer.
but you'd have to apply to the commission and say, it's like we're trying to sell our cultivation facility or something. If we were trying to do that, transfer it, how that would work.
Okay, I just clarify that.
And then it goes on, if the commission denies an applicant for transfer of the license, the commission shall provide written notice by certified mail or personal delivery to the licensee. The notice shall provide an explanation of the denial of the application. The licensee may request a hearing before the commission pursuant to section 18B of this rule,
Okay.
which then goes to the appellate procedure following the denial of the application.
Madam Chair, I did have one question. In looking at section 15, the change in information section, specifically it's little c3. When we start talking about the filing of bankruptcy, it says the filing of bankruptcy by the entity holding the license. That also probably needs to include any of the owners, which have already been made part of this as well. So if they have any of the financial stake within that, I think that would need to be included as well, because otherwise you'd have the trustee stepping into their shoes potentially in a bankruptcy situation. So
Can you,
Do you want to use that same language, board members, owners, principals, that we've used throughout?
well, if it's a board member, wouldn't necessarily have ownership interest. And the ownership interest might not actually, it's the ownership interest I'm worried about.
Okay,
Not necessarily just the,
board members or officers.
yeah, the board
Yeah.
members and officers are more controlling, and that wouldn't necessarily
Okay.
be affected the same way as the owners. And that would be, that's the other thing that we ought to, at some point, we ought to look at when we start dealing with this is, the 60% that's required to be owned by Arkansans. I think, we need to make mention of that. I know it'll come up today later, and we may just want to wait till we get to the forms, but it seems like we need a little bit more of that, either in section, it might actually go back in section 5. It's one of those pre-qualifiers.
minimum requirement?
Minimum requirement saying at minimum you have 60% of the ownership interest, like in your LLC owned by.
It is on page 3, under section 5, individuals applying on behalf of an entity must also provide the following proof. Under 2, documentation demonstrating the 60% of the entity's ownership, et cetera, there have been individuals of the state of Arkansas for 7 years prior to the application, and documentation sufficient to satisfy the requirement shall be the same as required of an individual in subsection